Thank you, Deputy Speaker, and I rise today to contribute to the Justice Legislation Amendment Trial by Judge Alone and Other Matters Bill 2022. And this bill seeks to reintroduce or extend temporary measures designed to assist the justice system in continuing to respond to the challenges presented by the COVID-19 pandemic. And I'm pleased that the opposition is not opposing this amendment bill, although they've indicated that they will be seeking to make some amendments in the other House. The bill has 5 aspects and they are reintroducing judge-alone criminal trials and special hearings on a temporary basis, which will ensure more criminal trials and special hearings can proceed. This will assist the courts in responding to the challenges presented by COVID-19 and minimise further disruptions and backlogs in the court system. And of course, we do know that there are backlogs, and this is an essential change to try and deal with that. It defers the commencement date for the de novo summary appeal reforms, which will allow the courts and other justice stakeholders adequate implementation time to ensure these reforms achieve their intended benefits while not diverting resources from backlog reductions at this critical time. It extends Part 16 of the Occupational Health and Safety Act 2004, which will provide certainty both for inspectors when considering issuing directions or prohibition notices under those provisions and for duty holders. It also extends the provisions requiring adult accused in custody to attend a summary contested hearing or a committal hearing by audio-visual link by default to reduce the need to transfer accused persons to court and for them to then complete transfer quarantine upon their return to prison. And this obviously is another health and safety measure in regard to the movement of offenders. And it extends provisions under the Children, Youth and Families Act 2005 to continue allowing attendance at a youth justice unit or reporting to occur by AVL or audio link. And look, in April 2020, the Andrews Labor government introduced reforms aimed at ensuring the justice system could respond effectively to the challenges that COVID-19 posed, including the introduction of judge-alone criminal trials. And of course, these reforms also applied to special hearings, and a special hearing is similar to a criminal trial, criminal jury trial, but for people who have been determined to be unfit to stand trial under the Crimes and Mental Impairment Act due to serious mental health issues or cognitive impairment. And the introduction of judge-only trials was aimed at assisting the court to continue to hear criminal trials and special hearings while there were significant constraints on conducting in-person jury trials due to the pandemic. And clearly it was about keeping people separated and distanced so we reduce the spread of this terrible virus. The measures operated effectively for 12 months between April 2020 to April 2021, and of course during that period there were 60 applications for judge-alone trials in the county court, of which 51 were granted, and there were 6 applications in the Supreme Court. And at the expiration of the scheme, it was not considered necessary at that time to further extend the provisions, as the return to in-person jury trials was expected to eliminate the need. But of course, the effect of public health restrictions caused us to re-evaluate that situation, hence this legislation being debated today. The courts are working hard to ensure that criminal jury trials can continue to operate in a COVID-safe manner. And jury trials resumed in the Supreme Court in October 2021 and in the County Court in November 2021. And both courts resumed jury trials for 2022 in January. So both courts have protocols in place to hold jury trials safely, including socially distanced arrangements and rapid antigen testing requirements. And substantial work was completed in 2021 to accommodate physically distant juries. And I have to commend the courts and thank them and the staff that work in the courts, all the staff that work in the court system, for keeping the courts safe and operational. And obviously that's dealing with that backlog that we keep talking about. So late last year, the government made legislative changes to provide the Juries Commissioner with discretion to defer jury service on health and wellbeing grounds, including vaccination status, to help ensure that the courts can run jury trials safely. So despite these measures, there remains a risk that criminal jury trials will continue to be disrupted due to the pandemic as COVID cases remain prevalent in the Victorian community. And we see that in our day-to-day lives, whether that be at schools, whether that be in workplaces, whether that be here in Parliament, where any of us could become a close contact or even be affected by COVID. So some criminal juries have been discharged due to COVID-19 reasons, and some have been adjourned. And in addition, potential jurors are seeking exemption from jury duty due to the pandemic. I've got to say, I was recently notified by mail that I was required to attend jury duty. Unfortunately, I've been exempted. And I've always wanted to have that experience of doing jury duty, but unfortunately the jobs I've held down have stopped me doing it, and I would have loved to have been on a jury, and I think it's important that we all play our part in participating in jury duty. I do think it's important, but it's a shame that